Good evening, friends. Welcome back. In this session on Isbp, we shall have a look at a non-negotiable C Waybill, paragraphs F1 to F25. Isbp paragraphs F1 to F25. When is article applicable? Article 19 is multimodal transport document. Article 20 is a BL. Article 21 is a non-negotiable C Waybill. When is a non-negotiable C Waybill applicable? If there is a requirement for a non-negotiable C Waybill, it can be however named, and it will be covering a port-to-port shipment. As long as there is no reference to a piece of receipt or a taking in charge, so that it doesn't lead to a multimodal situation. As long as it does not contain any indication of charter party, so it does not lead to a charter party BL, and it need not be titled as marine BL or an ocean BL or port-to-port BL. Then in such a situation, Article 21 will be applicable, and a non-negotiable C Waybill will be checked under Article 21 of UCP. Issuance, identification of carrier, signing, etc. The non-negotiable C Waybill may be issued by any entity other than the carrier or master, but it should be signed as per the requirements of Article 21. It can be issued by any entity. If the credit indicates freight forwarders non-negotiable C Waybill acceptable or house non-negotiable C Waybill acceptable, then it may be signed by the issuing authority without indicating capacity, without indicating the name of carrier. If the credit is silent, it can be issued by any entity other than carrier or master, but signed as per Article 21. UCP says it should be issued by the carrier or master or signed by agent for or on behalf of carrier or master. And Isbp clarifies that if freight forwarders non-negotiable C Waybill is acceptable, then carrier need not be identified and the issuing party need not indicate their capacity, and they can just assign as issuers of such a BL. If the credit says non-negotiable C Waybill freight forwarders or house not acceptable, then it has no meaning in the context with regards to title, format, content, or signing. The words freight forwarders non-negotiable C Waybill not acceptable does not give any clue as to title, format, content, or signing of a document which is not acceptable. So the credit has to further state what is exact requirement, how it is to be issued and signed. If the credit does not state, and if it just states freight forwarders non-negotiable C Waybill not acceptable, then the document submitted will be checked under Article 21. This is what the examination of documents will be subject to Article 21 for the presentation of such a transport document. When it is signed in the form, the transport document submitted should be signed in the form as given in Article 21A1. And when an agent signs, it should indicate as agents for carrier, name of the master need not be stated, carrier has to be identified. The transport document can be issued or signed by carrier or master, and if agent is signing, agent should indicate the agent is acting as agent for carrier or as agent for master, and in such cases the master's name need not be mentioned but carrier's name has to be mentioned. Coming to if the transport document submitted is a pre-printed shipped on board BL. If the transport document submitted is a pre-printed shipped on board BL, then the issuance date will be considered as a date of shipment, unless there is a separate onboard notation, which then will be the date of shipment. This is for pre-printed shipped on board BL. Notwithstanding the fact that the credit may need to evidence a port-to-port shipment, notwithstanding the fact that the credit may need to evidence a port-to-port shipment, the non-negotiable C Waybill may indicate a place of receipt, not a port, but a place of receipt, which is different from the port of loading. Then, if there is no indication of a means of free carriage can be by indication in its own field or by indication of some data in the place of receipt field. If there is no indication of a free carriage, and if the port of loading and the place of receipt are different, if it is received for BL, then a dated onboard is required. If it is received for BL, a dated onboard is required. If it is shipped on board BL, then there is no need for a separate onboard notation on the non-negotiable C Waybill. When the non-negotiable CEV bill indicates a place of receipt same as the port of loading. If the place of receipt and port of loading are the same, but because something is mentioned in the place of receipt, there is a clue that there could be a pre-carriage. So if there is no indication of a pre-carriage can be by either mentioning a name of a pre-carriage or by mentioning a place of receipt. Just like this, both the places being same is one being a container yard and other being the port. If it is received for BL, then a dated onboard is required. If it is not received for BL, but if it is shipped for BL, a dated onboard is not required. And whenever this dated onboard is required, such date will be considered as the date of issuance of the transport document or the date of shipment for all practical purposes. When the credit requires the port to port to be evidenced on the non-negotiable CEV bill, and the transport document indicates a place of receipt different from the port, the transport document indicates a place of receipt different from the port of loading. If there is an indication of pre-carriage, means of pre-carriage means maybe a vessel or maybe any other truck or anything. If it is pre-printed or received, irrespective of whether it is pre-printed shipped or pre-printed received, a dated onboard is required. If there is an indication of pre-carriage, a dated onboard is compulsory. And irrespective of whether the fact that whether it is a pre-printed shipped BL or pre-printed received for shipment BL, a dated onboard is required. This indication of pre-carriage can be either in the pre-carriage field or in the place of receipt field, and it can be if it's a different port, place of receipt and a place of port of loading being different, or use of an pre-carriage vessel or pre-carriage truck or whatever. The transport document should indicate the port of loading stated in the credit. The transport document should indicate the port stated in the credit. If it is indicated in the place of receipt field, then there has to be a dated onboard notation. So these are the situations on which a dated onboard notation is required, and such a date on the onboard notation will be considered as shipment date for all purposes with respect to last date for shipment and the presentation period and calculation of tenor. When the credit indicates a geographical range, any European seaport is the word used in the credit, then the transport document, that is a non-negotiable CEV bill, should indicate the actual port and need not mention the range. When the credit requires a shipped on board BL, the words shipped in apparent good order or laden on board or clean on board would be adequate to meet this requirement of shipped on board. If the named port is not appearing on the port of loading field, then definitely an onboard notation is necessary. When the transport document indicates more than one port of loading, then the onboard notation with the relevant onboard date for each port of loading is required. When the transport document indicates more than one port of loading, the relevant onboard for each port is required. And whether it is pre-printed received BL or a pre-printed shipped BL, this onboard notation will be required for each port. With respect to port of discharge, when the credit stipulates a discharge port, the named port of discharge should appear on the credit, on the transport document. When the credit stipulates a discharge field, definitely it will stipulate because it's a non-negotiable CEV bill. Such a port, the port mentioned in the credit, should appear on the transport document port of discharge field. If it is mentioned in any other field, for example, place of final destination field, there should be a notation that says the port mentioned in the place of destination, place of final destination is actually the destination port or discharge port. When credit indicates a geographical range for a discharge port, the transport document should indicate the actual port of discharge. The name of the country need not be stated on the transport document. The name of the country of the discharge port need not be stated on the transport document. Now let us turn our attention to the original. What is an original? The transport document should indicate how many originals have been issued. It could be called as first original, second original, third original, or duplicate, triplicate, and original. Either ways, such originals will be accepted because all are equally same originals. And the document has to indicate how many originals have been issued. Now, consignee, order party, shipper, endorsement, and notify party. Consignee, order party, shipper, endorsement, and notify party. Consignee, when the credit states the goods are consigned to be a named entity, that is, when the credit wants a straight consignment and not to order consignment, then the words to order or to order of or order should not appear on the transport document. When the credit states there is a straight consignment requirement, the words to order of or order should not appear on the transport document. When the credit requires consigned to a named entity, it may indicate that goods are consigned to the entity. When the credit requires to order of a named entity, the goods can be consigned straight to the entity. when the consigned to the order of, without naming the entity, consigned to either the issuing bank or the applicant. When the transport document called for in the credit, the non-negotiable CVA bill has to be consigned to order without naming the entity, is just to order, which is a blank negotiable instrument. Then the consignment can be consigned to the issuing bank or the applicant. When the credit requires a named entity, it can be consigned to that entity and to order is not required. Why this to order is not required? Or when the to order is called for, it can be consigned straight to the bank or applicant when it is a not named entity. Why is this so? This is so because the non-negotiable CVA bill is not a document to title. It is not a negotiable instrument. It cannot transfer title by endorsement and delivery. And so the concept of to order mentioning in the consignee field does not add value. That is why Isbp says it is permissible to be consigned either straightaway to the party entity mentioned in the credit, or consigned to the bank or applicant if it is not mentioned in the credit, and if it is be consigned to a specific party, then straightaway consigned to that party. Regarding notify party, if the credit stipulates the details of one or more notify parties, the transport document can indicate that and any other additional parties. If the credit does not stipulate notify party, transport document can state any notify party. And if applicant is stated as a notify party, it should not conflict with the credit. And if applicant's address is used in the notify party, it should not conflict with the credit. If the credit requires goods to be consigned to the issuing bank or the applicant, or notified to the issuing bank or the applicant, then the issuing bank's or applicant's name should be appearing and the details need not be there. What details need not be there? Contact details or the addresses, detailed address, pin code and phone number, all those things need not be there. And if it is mentioned, it should not conflict with the credit. Now let's have a look at transshipment. What is a transshipment? For the purpose of this article or the non-negotiable CVA bill in this context, transshipment is unloading and reloading of goods from one vessel to another, because non-negotiable CVA bill is nothing but a BL. So it is from one vessel to another during the carriage from the stated port. Stated port is a port of loading and port of discharge stated in the credit. If the unloading or reloading happens between these two ports during the voyage, during the carriage, then it is transshipment. If not, it is not transshipment. What is partial shipment? Partial shipment means shipment on more than one vessel. Shipment on more than one vessel. Even when the vessel leaves on the same day, on the same to the same destination. If it is the same voyage, same vessel, same day, same destination, even then more than one vessel will be considered as partial shipment. Why? You cannot have same voyage and same vessel, because the very definition of partial shipment says shipment on more than one vessel. When the credit prohibits partial shipment and more than one BL is submitted, the shipment can be from the ports, more than one ports in the given range, more than one BL is submitted. Each BL should indicate same vessel, same journey, same destination. When the credit prohibits partial shipment, each transport document should state same vessel, same journey, same destination. If it is a different vessel or a different journey, it will become partial. That is why the document should indicate same vessel and same journey. When different dates of shipment are mentioned, the latest date will be considered for presentation period and latest shipment date. The latest date will be considered for presentation period and latest shipment date when credit prohibits transshipment. When credit allows transshipment, the earliest date will be considered for calculation of presentation period and calculation of shipment date. Earliest date. Earliest date of what? Multiple transport document incorporating different dates of shipment. When partial shipment are allowed, multiple transport documents presented with the different dates of shipment, earliest dates will be considered for presentation period and latest shipment date. It can be on a same or a different vessel. Because partial shipment is allowed, being on different vessel doesn't make a difference because partial shipment is allowed. What is clean? Clean means the transport document should not indicate a defect in the goods or packaging. Expressly declare defective condition. This is the operative part of the phrase, expressly declare defective condition. So if the transport document indicates a defective condition of goods or packaging, it is not clean. Not necessary for the word clean to appear in the transport document, or the deletion of word clean does not make it defective. And the examples as usual, packing is insufficient versus packing may be insufficient. Description of goods. The description of goods mentioned in the transport document, that is a non-negotiable CVA bill, may be in general terms, not in conflict with the credit. Description can be in general terms, not in conflict with the credit. Delivery agent. when the details of delivery agent is called for in the credit, when the details of delivery agent is called for in the credit to appear in the transport document, the delivery agent need not be in the same as in the place of destination. The delivery agent address need not be same as the place of destination, and it need not be in the same country as the place of destination. The delivery agent mentioned in the transport document need not be in the same country or same place as the destination. Corrections. Any correction is to be authenticated. Authentication should be by the carrier or master or agent. If the agent issuing the transport document and the agent authenticating the transport document are different, it is not a problem. But the agent should identify themselves as agent for the carrier, and it should be for the same carrier, and carrier has to be identified. Non-negotiable copies need not be authenticated. Corrections can be authenticated by a different agent provided they identify themselves as agent for carrier, and non-negotiable copies need not be authenticated. Freight and additional costs. A statement regarding payment of freight called for in the credit need not be identical to the one stated in the credit. If this credit calls for freight collect, then the words freight payable as destination can be mentioned. And it should not conflict with the data in the document, data in other document, or credit. And it need not be same as in credit. Freight collect versus freight payable at destination. If the credit states that cost additional to freight are not acceptable, then it should not indicate cost additional to freight have been incurred or cost additional freight will be incurred. When the credit prohibits cost additional to freight, transport document should not indicate cost have been incurred or cost will be incurred. What cost? Cost additional to freight. An indication of cost additional to freight may be by means of express reference to such cost or usage of Incoterms like FIOS in addition to CFR or FOB. The reference to cost which may be levied is not an indication of cost additional to freight. There are certain costs which may be referred that could be levied, but they are not indication of cost additional to freight. What cost? Detention and demurrage cost. That is the cost covering the late return of container as a result of a delay in unloading the goods, the ship staying in the port for a longer time, the container staying in the port for a longer time, or cost incurred after the goods have been unloaded. Surrender of BL. If the transport document indicates, the non-negotiable CEV bill indicates that more than one CEV bill has to be surrendered for release of a container, then such a transport document is not acceptable unless and until all the BLs mentioned in such a clause is forming part and parcel of the same presentation. So this is a small snapshot of what Isbp has to say on non-negotiable CEV bill. We'll come back to another video on the other transport documents. Thanks for watching.